up, guys? Welcome back to Unit 2, Outcome 3, Key Knowledge 7. This one is on something called the National Employment Standards. Now, this is one of those key knowledge dot points which you will not be familiar with. Well, it's extremely unlikely you will be. This is not one you can kind of blag. So this is definitely one that you'll need to pay attention to and make some good notes, because this is going to be new stuff to you, I think, on the whole. So here is our study design as always, and here is where it's sitting, just says overview of the National Employment Standards. So what is this all about? Okay, so the National Employment Standards, the NES, the minimum entitlements that an Australian employer owes its employees. Okay, that will make more sense as we move through this to put that into some context. Okay, they're included in the Fair Work Act 2009, which is one of the main pieces of legislation that covers workplaces in Australia. And it is through this piece of legislation that the government protects the rights of Australian employees. So that's what this is all about, okay, protecting Australian employees, okay. The NES, these standards, they came into effect in 2010, so 13 years ago. Originally, there were 10 of them, and then in 2021, so 2 years ago now, as of 2023 when I'm recording this, they added in an 11th, and I'll point that out to you as we go through them. Now, what basically these standards do, or what they mean, is that ensures Australian employees can't be exploited by employers, okay? So it kind of creates a safety net for employees in the workplace. So it means that employers can't exploit, can't take advantage of workers, because there's these rules put in place, which you'll see as we go through them, which basically protect workers. It sets in place some minimum standards that employers have to meet with respect of their employees, okay? Now, these entitlements that we're going to look at cover all part-time and full-time workers in Australia. Doesn't matter how much you're earning, what job you're in, what industry you work in, this covers all Australian employees. That's a really important thing to remember. Covers everybody in the workplace. Now, when I say everybody in the workplace, casual workers. Now, a lot of you have part-time jobs. I would assume that you would know if you are employed on a casual basis or a part-time basis. Like, none of you would be full-time, obviously. But if you have a job right now, you're going to be employed either on a part-time basis or a casual basis. And I would expect that you would know which you are. You certainly should do, because you have different entitlements, and your pay would be different if you're one or the other as well. If you are not sure which you are, you probably want to find out. Now, casual workers have less certainty about their ongoing work. Yeah, that's kind of one of the main differences between permanent part-time employees and casual workers. Okay, so you have less certainty about your shifts and about whether you're going to be employed into the future, so on and so forth. But also, the casual workforce, some of these entitlements that we're going to look at apply to them, but not all. Okay, so that's another key thing to remember. So when I say the entitlements apply to all workers in Australia, some of these entitlements do not apply to casual workers. Some of them do. And we kind of point that out as we go through as well. So businesses have to make sure they're legally compliant with each of these 11 standards, okay? This is a piece of legislation. Like any legislation, people in society, businesses, whoever the legislation applies to, have to remain on the right side of those piece of legislation and those laws. Otherwise, fines can be issued, which are going to be damaging to the business's reputation potentially. Now, it's actually the Fair Work Ombudsman who would investigate allegations of breaches or non-compliance with the Fair Work Act 2009, which I said this is part of. And they also can provide advice to employees and employers around all of this sort of stuff. And if there's any disputes around this stuff, they would also get involved as well. So it's the Fair Work Ombudsman, which is the government department that kind of looks after this stuff, is, I guess, what we're saying. So what is this all about? Yeah, employee rights, basically. It's about the rights that Australian employees have with respect to their workplace. Fundamentally, that's what underscores all of this, and protecting those rights. So we'll just talk through the standards. Now, you wouldn't need to explain, you wouldn't have a question in a SACA exam which says, explain all of the 11 standards, but it's good to have an understanding of what's kind of behind each one and actually to be able to explain a few of them if you were called upon to. So let's talk through each of them. Okay, so standard 1 refers to the maximum weekly hours of work. Now, for a full-time employee in Australia, 38 hours is the standard working week, as stated in this legislation. Now, the standard also says that employees may be required to work a reasonable number of additional hours, but the employee has the right to refuse unreasonable additional hours. Part-time employees can't be required to do more than 38 hours or any additional hours to their ordinary weekly hours, whichever is less. So that if you have a job right now, that second part would apply to you because you're part-time. Now, something I'll point out here, these standards, the way that the wording is used is sometimes a little bit vague and woolly. And here's an example. When it says, may be required to work a reasonable number of hours, and the employee has the right to refuse unreasonable additional hours. Like, what's reasonable, what's unreasonable? At the end of the day, if there was a dispute over this, like if the employer was expecting, an employee to work, say, an extra 10 hours a week, and the employee thought that was unreasonable, then, like we said before, you could go to Fair Work Ombudsman and they would get involved in any disputes. But you will find, that some of the wording in these standards does leave a little wiggle room, which at the end of the day is probably not very helpful. It would be easy if they were just black and white, but they're not all like that. So that's your maximum weekly hours. So 38 hours a week plus reasonable additional. Standard 2 is all about requests for flexible working arrangements, okay? So according to this legislation, an employee can request a change in their working arrangements for circumstances, including if they have caring responsibilities, okay? So if you are a parent of young kids, if you have disabled relatives, if you have older parents, whatever those caring responsibilities are, okay? And the idea is that you have the right to go to your employer and say, look, I need to change my hours, change something with my work to allow me to, still meet those caring responsibilities. Must have completed 12 months of continuous service with the employer before making those requests. Some examples here of flexible working arrangements: starting or finishing work earlier or later, working from home, working agreed hours over fewer days, changing hours of work. So that sort of stuff we're talking about. And in fact, I'm an example of this. I'm on a flexible working arrangement so that I can meet my caring responsibilities, because I have 2 kids right now who are at primary school. There's 1 day a week I need to pick them up from primary school. So I'm on an official agreement with the principal at the school to leave straight after the final bell of the day to go and pick them up. And I get to choose which day it is, because it depends on what days I have meetings and what my wife's schedule is like. But 1 day a week, I can leave early to pick up my kids. So that's an absolute example of standard 2 in practice. Standard 3, this is the one that came into effect in 2021. So this is the new standard, if you like. And the reason this was added, if you look at what it's about, offers and requests for casual conversion. So basically the feeling was, up until about 2020, that casual workers had very few rights as compared to their their ongoing permanent counterparts. So casual workers were kind of at risk of being exploited in the workplace. So this one was kind of put in there to kind of readdress that balance, if you like. So what this one says is that casual employees must be offered to convert to full-time or part-time work if the employee has been working at the business for at least 12 months. Okay, and if that's not offered by the business, the employee can actually make that request. And the employer can only refuse that request if there are reasonable grounds. And again, there's what's reasonable. It's a bit vague. But again, if there was any dispute, you go to the Fair Work Ombudsman and they would resolve it for you. But look, this is actually a good thing, because some people have been employed on a casual basis for many, many years. And you don't have the security that permanent employees have. You don't have the same entitlements. So this was to kind of get around that. So businesses couldn't exploit workers by keeping them on casual basis for years and years and years, because it meant that they didn't have to commit to them as much. So this was actually a really, really good one. It means that casual workers are converted, and then they get all the rest of the entitlements, rights, and all the rest of it, and the benefits that the permanent employees get as well. So this was definitely very useful and a long needed standard to include. Standard 4, parental leave and related entitlements. Employees are entitled to various types of parental leave once they've completed 12 months service. Okay, parents have a right to separate periods of 12 months of unpaid leave up to a total of 24 months, and the right to return to their old job. So that's key. So if you're a female who goes off and has a baby, it's fairly standard these days to have 12 months off. Some have less, some have more, but a year is a fairly standard thing. The right to return to the old job. So in other words, what that's saying is while you're on maternity leave, they can't give somebody else your job. Now, they absolutely can and usually will get someone to do your job while you're away. So they would employ someone on a temporary contract basis, because at the end of the day, if your job needs to be done and you're on maternity leave, someone needs to do it. So then they would employ someone on a 9-month, a 12-month, however long the contract is that you're not going to be there for. But you have the right to come back to that job when your leave is up. So they can't say, for example, decide that the person that's doing your job on contract while you're on maternity leave, they can't just go, this person's better, you stay, we don't want you anymore. You're on maternity leave. According to Standard 4, you have the right to come back to your job. Okay, so that's a pretty key one as well. Standard 5 is about annual leave. All full-time non-casual employees. So here, this is a key, non-casual. So when we said originally that some of the standards apply to casual employees and some don't, so here is one that does not. So full-time non-casual employees are guaranteed 4 weeks of paid annual leave each year, and part-time employees pro rata. So in other words, if we said the working week is 38 hours. If you are part-time and you work 19 hours, which is half of 38, then you would get 2 weeks. It's just scaled down exactly to how part-time you are. So if you work 1 day a week instead of 5, you'd get 20% of the 4 weeks, so on and so forth. So look, some people get more leave. A lot of people I know have 5 weeks annual leave a year, 6 weeks. That's a choice that your employer is making. They don't have to offer that. But as a legal minimum, if you're a full-time employee, you're guaranteed 4 weeks at least of paid annual leave. Certain shift workers might be entitled to some additional paid time, like an additional week or something. But again, that depends on the shifts and how that works. But fundamentally, what you need to know is that all permanent full-time employees in Australia, minimum 4 weeks a year. And that's fairly standard across most of the Western world. That's pretty the same in the UK. I believe in America, most Americans only have either 1 or 2 weeks paid annual leave a year. They don't get much time off at all. But across most of the developed world, 4 weeks tends to be the standard way to go. Standard 6, personal carers leave, compassionate leave, unpaid leave, domestic violence leave. Okay, so there's lots of different leave types kind of bundled into this one. 10 days of paid personal and carers leave each year. And again, part-timers pro rata. That's always how this works. Whenever these entitlements involve time off or whatever, part-timers are always pro rata down to whatever the proportion of the working week they actually work. Also entitled to 2 days paid compassionate leave on the death or serious illness of a family member, 2 days of unpaid leave where required for genuine caring purposes and family emergencies, and 5 days of unpaid family and domestic violence leave each year. So again, just to emphasize the fact these are all entitlements, okay? Your employer has to meet these requirements as a legal minimum. Okay, again, some companies choose to go above and beyond all of this leave stuff and offer way more. And, they might do that for reasons of attracting staff and retaining them, whatever the reason for being socially responsible may be. But these are the legal minimums that as Australian employees, we are all entitled to. and all Australian employers need to make sure their employees are getting. Community service leave standard 7. So employees including casual employees. Here's one that does include your casuals. They can take leave for activities such as voluntary emergency management activities, jury duty, or general community service stuff, basically. So other than jury duty, community service leave is unpaid. Okay, so your employee doesn't have to pay you for the days that you do this. There's no limit on the amount of community service leave an employee can take, but the employee must provide ample notice and evidence of what they're doing. So this is basically just going out and volunteering and doing some good in the community. Okay, and we'll refer back to this, I think, in the last key knowledge dot point of the outcome as a way of businesses actually demonstrating social responsibility. But we'll leave that for there. So yeah, community service leave is another thing that we're kind of entitled to, but you just need to arrange it with your employer and give them plenty of notice. They can kind of work with it. Standard 8, long service leave. I love this one. This is, I don't know if it's uniquely Australian. I don't know of any other country where this happens. Certainly doesn't happen in the UK, but period of leave granted to an employee has served a specified period of continuous employment. Now, the rules around this, like I said, this is an Australian thing, but the rules around it and exactly how it works out and how much you get is state-based. But the rules and entitlements are set out in the employee's award agreement or employment contract. Okay, so whatever contract you're working under, how long service leave accrues and can be taken will be stipulated in that contract. So in Victoria, accrues at a rate of 1 week for every 60 weeks of continuous service, which equates to 0.866 of a week for each year that you work. And the idea is, so you build up this over, say, a period of time, and then you can just take a big lump of leave in one go. So as teachers, the simplest way to look at it, this isn't exact science, but once you've been a teacher for 10 years working for the Department of Education in Victoria, you get to take pretty much a term off. So you could take one term off and then you start back at zero again in terms of you accruing it. But like I said, this is a really good one. I'm not aware of any other country that does this. This is an awesome one. So when I moved to Australia, I had no idea about this. I'm now due for, I've accrued, I've never taken any long service leave. I've been working for the Department of Education for 13 years. So I'm due a fairly big lump of holiday. Don't know what I'm going to do with it or when I'm going to take it, but it's sitting there anyway. So yeah, that's a great one. Standard 9, public holidays. Look, this one guarantees the 8 national public holidays, plus then the prescribed state and local holidays. So there's 8 public holidays which apply right across Australia, and then each state and territory has an additional 4 or 5 as well. So this guarantees those. Where an employee works on a public holiday, these standards guarantee that an appropriate penalty rate or other type of compensation is provided to the employee. And again, that's going to be set out on whatever type of employment contract the employee is working under, whether that's an award, an agreement, or other type of employment contract. So whenever you begin work, you should get some documentation surrounding your contract, unless you're casual. That doesn't have to happen. And it would state out the penalty rates or how it's going to work if you end up working on a public holiday. But the key point here is you need to get something in return. There is some kind of compensation due to you if you end up working on a public holiday. As of 2023, there's 13 official public holidays per year in Victoria. Okay, moving on, standard 10, notice for termination and redundancy pay. Okay, employees are entitled to fair notice of termination provided in writing, and that notice period ranges between 1 and 4 weeks, depending on length of service. Usually the way this works is, with most businesses, and kind of the expectation is the notice period that you provide would be linked to your pay cycle. So in other words, what I mean is if you're paid weekly, you should give 1 week's notice that you want to leave, or the other way around, the business needs to give you 1 week's notice if they're going to make you redundant. If you're paid fortnightly, then you would you would or the business would need to give 2 weeks notice, and if you're paid monthly, 1 month, so on and so forth. You'll find very, very senior roles, often it's actually written into their contract that they have to give 3 months or even 6 months, because to replace a very senior role such as a CEO of a large business or something can take months to do. So it's often written into their contract right up front that the notice of termination that would be needed to be provided is much longer. Those who are made redundant and who are employed in workplaces with 15 or more employees are entitled to redundancy pay. And again, that is dependent upon length of service. And there's actually tables you could look up. So if you've been working with a business for 12 months, this is how much you're entitled to. And it's linked to the actual pay that you get. If you've been here working for 2 years, you get this much, 3 years, so on and so forth. But basically, the longer you've been working in a business, if you're made redundant, the higher your redundancy pay. But again, the key and the point of this is that this is a legal requirement. Businesses have to provide that redundancy pay to employees who either making redundant or retrenched, 2 different words meaning the same thing. But it does only apply to workplaces with 15 or more employees. That doesn't mean to say that a business that employs fewer than 15 cannot do this, but they're just legally they don't have to. Okay, but for reasons of social responsibility and various other reasons, they might choose to, but legally this only applies to 15 or more employee businesses. Okay, and then standard 11, the final one, Fair Work Information Statement. Look, this just says that basically employers must give new employees a statement before the employees starts their employment. This is just some paperwork, and it's just paperwork that includes information about what the employee's rights are, what their entitlements are under the National Employment Standards, and also a bit of information about the respective roles of the Fair Work Commission and the Fair Work Ombudsman. Okay, there's a separate version for casual employees, but still legally you're supposed to get something. So again, all of this stuff you can think back to your own job. If you have a job, are these standards being met by your employer? And very often over the years, I've had students come and talk to me about their workplace, and very often they're not. And if they're not, then you have recourse to address that. So this is stuff that is, forget the course and learning this for a SAC or an exam or whatever. This is just useful stuff to know in real life, because if you're not aware, this is one of these things, if you're not aware that it exists and this is in place, it's pretty easy for you to get exploited by your employer. And trust me, it isn't always just the random one-off, dodgy fast food places that exist on some of these shopping strips that do this. Fairly often it's the big major companies that employ lots of people that kind of fall foul of some of this stuff. So look, it's worth being aware of and thinking about how this applies into your own job and your own employment. So when you started, were you provided with some documentation like this? Because if you weren't, then your employer was basically breaking the law. Right, just touching on casual employees again here, just to re-emphasize that point. Casual employees only receive certain of those 11 entitlements. For example, casual employees are not entitled to certain leave, and we looked at a bunch of different types of leave categories. So casuals are not going to be entitled to all of those until they've served continuously for 12 months. And again, if you're a casual employee, looking at 11, what do we call it again? Standard 11. There's a separate version for casual employees. You should actually have that from your employer, which sets out what your leave entitlements are. Now, look, there's many, many more details around all of this, but for our purposes for this course for now, just know that some of the standards apply to casuals, some don't. If you are a casual, like I just said, you'll just need to refer to the statement as per standard 11 that you should have received. But my bet would be that probably most of you didn't. That's going to tell you your entitlements. Okay, so that is it for National Employment Standards. Hopefully that makes some sense. But also, like I said just before, think about those in terms of your own employment and, work out if you're being exploited yourself, because it's really not unusual for employees, particularly casuals, even though they're protected under the law more than they were since the introduction of the new standard in 2021. There's still a lot of businesses that still don't do the right thing. So if you are a casual employee, you're definitely kind of more at risk of exploitation, despite there now being more protection. It's worth having to think about. And look, if you've got any questions around your own employment, you are welcome to come and talk to me as well. And if I can offer any advice, I will do so. All right, that's it for guys. See you in the next video for Key Knowledge 8. Cheers for now.